Good day, Crime Talk aficionados. The prosecutors responded to the Karen Reed's motion to dismiss. Rex Huerman is trying to make that pesky DNA go away. Another teacher was arrested again. We have this day in legal history and our dumb criminal of the day. Let's talk about it.
Lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, hit that bell for notifications, and you can check us out anytime on any of your favorite podcasting apps. Before we get to the docket, go to crimetalksearch.com, sign up for that background subscription service today. When you do, you'll be able to search anyone here in the United States and have a background subscription report prepared literally while you wait. It is emailed to you, and it is updated as well if new information becomes available. That information is going to be social media presence, whether people have property, whether they have debts, judgments, do they have a criminal history, are they on one of those registries, everything you want to know about somebody either coming into your life or maybe you're not sure that they should be in your life and you should get them out of your life. Go to crimetalksearch.com, sign up today. You can search anyone. All right, let's go ahead and get to the docket today for, can you believe it? Friday, February 28th, the last day of February. The year is flying by. First on the docket, the prosecutors respond to the Karen Reed motion to dismiss. We talked about that a bit yesterday. I went through it last night, all 147 pages of it. It's a lot of the same stuff, the stuff that hasn't been redacted, so to speak. It's not going anywhere, ladies and gentlemen. It's not going anywhere. The defense is now moving to continue the hearing that's set for next week. And the prosecutors are saying, no, let's go to hearing. We'll be ready. The defense is saying they're going to get a few more videos in the Sallyport, which is a big deal for the defense. And at this particular time, the prosecutor is saying, we don't even know. This may already be turned over. There's some new chain of custody information that is apparently coming down. But I'm just looking at this in a practical sense. We're probably talking a couple of minutes of actual relevance as it relates to these Sallyports, that it's not like it's a crime scene. And all of a sudden, this has become the hanging point for the defense. I get it. They're trying to show that there was no damage to the vehicle when the car came into the Sallyport. But if the evidence isn't there, it isn't there. Anyway, let's move on. So prosecutors are asking the judge in the Karen Reed case to deny Karen Reed's motion to dismiss and say, let's get this trial going on April 1st. Now, in the 147-page motion, which includes exhibits, which was filed on Wednesday, Reed's attorneys asked the judge to dismiss her case for extraordinary governmental misconduct, alleging that the prosecutors intentionally manipulated video evidence and tampered with the jury in the Karen Reed's trial, her first trial. In the motion to dismiss filed by defense attorneys, the attorneys alleged that prosecutors altered or inverted certain surveillance video showing Reed's car at the Canton police station in a deliberate attempt to defraud the jury into believing that no one approached or touched the right rear taillight. Contrary to the defense theory that Trooper Michael Proctor manipulated Reed's taillight and planted evidence at the scene. Now, to rebut this, the prosecutors say in their motion that they made all video available to the defense team and they have received it, and that for several pieces of video, they had not been alerted to its existence by the investigating officers. Now, prosecutors say that the Canton Police Department Sallyport camera has since been replaced due to its defective condition, which they say is responsible for the poor quality of the video. not some sort of manipulation by the police to defraud the jury. Anyway, in addition, prosecutors claim the so-called inverted Sallyport video was inverted due to its camera settings and not any intentional manipulation. Now, the prosecutors dispute Karen Reed's assertion that the status of her taillight while in the custody of the Canton Police Department is the most critical and highly contested issue in this case. The Canton Police Department is not the alleged crime scene. The prosecutors note in their response, the Commonwealth cannot reasonably have anticipated the defense ever evolving into some sort of third-party culprit claims that they now allege. Now, it was revealed at Miss Reed's first trial that witness Jennifer McCabe made a visit to the Canton police officer Michael Lang's house in the day after John O'Keefe's death. Now, McCabe said that she was dropping off a friend's daughter and didn't go into the house other than to use the restroom, an allegation defense attorneys dispute, and they argue that in their motion to dismiss. In the prosecution response, the prosecutors note that the lead attorney for the defense, Alan Jackson, was given the opportunity to call Miss McCabe back as a witness, and the defense declined to do so. Now, perhaps the newest claim in the defense motion to dismiss, a claim never made in court, documents prior, was an allegation of jury tampering. The defense motion was so heavily redacted that no details were available, but the Commonwealth's response reveals a bit more about the allegation. Defense attorneys appear to allege that the Massachusetts State Police Detective John Fanning was in charge of the jury during the trial and improperly interfered with jurors, a claim that the prosecution denies. The defendants claim that a lieutenant of the Massachusetts State Police was in charge of jury security is patently false. At no time did Lieutenant John Fanning having contact with nor control or influence over the trial jury, nor was there jury tampering that deprived Miss Reed of her constitutional right to a fair trial. Lieutenant Fanning was one of the commanding officers who was involved in the safety and peacekeeping efforts outside of the courthouse, the prosecution notes in their response. At no time did Lieutenant Fanning enter the Norfolk Superior Courthouse during the defendant's trial. Moreover, they state he never saw, let alone speak to any members of the jury. Now, this motion is set to be argued on Tuesday, March 4th. However, defense attorneys have asked the court for a delay in the scheduling as they expect to receive chain of custody logs and even more surveillance videos from prosecutors, which they say could impact their motion. The prosecution opposes the scheduling change, saying they will be prepared to argue the motion on March 4th. So, ladies and gentlemen, the attorneys for Karen Reed filed this motion Tuesday. Right? Wednesday. They filed it Tuesday. The prosecution has filed their response as of today. Okay. Usually attorney is like, oh, I needed more time. I need 147 pages. I need to respond. This Brennan guy, he's on top of this and he's saying, let's go. Let's rumble. The defense is now the one seeking to delay. Like I said, I know I'm going to get all the haters. I'm going to get the haters. But the reality of it is I've said at the first trial, I would have found Karen Reed not guilty. And I've said the defense never does better the second time around. I think my theory is proving true. We'll see how it ultimately plays out at trial. But now the defense is on the defensive. They were clearly in charge after the first trial. They kicked butt in the first trial, but the wheels are now coming off. The only way I see this trial getting continued is if the judge boots off Alan Jackson and the other attorneys for alleged misconduct, if she so concludes. But one way or the other, I think if she doesn't kick them off and maybe waits for any sort of penalties or sanctions until after the trial, I think this trial will begin on April 1st. Now, a lot of people are talking about the fact that the prosecutor, who's a special prosecutor, Mr. Hank Brennan, was set to make via a contract of up to $75,000 for his work trying the Karen Reed case. And some public records have revealed that that contract has since been modified. And now Mr. Brennan can make up to $225,000 for his work on the case. I would say definitely that the $75,000 was an underbid. The $225,000 is much more reasonable. And frankly, given that his hourly rate is only $250 per hour, this seems quite reasonable given the amount of time that he has had to put into this case. So, as I noted, Hank Brennan was hired as a special prosecutor by the district attorney's office to try Reed in her second trial. Now, the Norfolk Assistant District Attorney, Adam Lally, tried Reed's first case and is still on the team trying her second case, along with Assistant District Attorney Laura McMullen. Brennan is working under a maximum obligation contract, which states that his maximum pay will be $225,000 for this case. Like I said, it was amended. He's being paid $250 per hour, which is below the going rate for private attorneys, and I am sure that that is probably at least half of what his normal hourly rate would be there in the state of Massachusetts. Now, to give a little context, the district attorneys that are on the case make $145,000 and Ms. McLaughlin make $119,000. But guess what? They're public servants. Mr. Brennan was not. They paid him a fee to come in and try the case. It's reasonable. I don't think people should be complaining about it. The man has a right to make a living. It's public information. We'll see how he does. We'll see if it was worth the juice was worth the squeeze, so to speak, by bringing in a former prosecutor and defense attorney to try the case for the state, because apparently they thought they were outgunned by the defense. Seems to be he's holding everyone's feet to the fire. Can't wait for next week. We'll see how things play out in the Karen Reed case. Will Alan Jackson remain on the case? Will he be sanctioned? Are we going to trial on April 1st? I think we are. Next, Rex Huerman. Guess what? He wants that pesky DNA to go away. Boy, does that sound familiar? I know some people say, oh, it's just DNA. But unless it's in your house, where you'd expect to find your DNA, if your DNA is at a crime scene, sometimes you got some explaining to do. Trust me, I have tried these cases, ladies and gentlemen. I'm not trying to sound braggadocious. I'm not trying to say I've done it all. I haven't. But let's be realistic. If there is a bad piece of evidence in your defense case, you need to sit there and think, how do I make this go away? Well, the Rex Huerman case, the bad piece of evidence is the DNA evidence. So what are they trying to do? Say, Judge, you can't trust this lab. They're not accredited in the state of New York. Keep it all out. Nice try, but I don't think that argument is going to fly. So Rex Huerman was back in court. His defense team pled with the judge not to accept DNA findings as evidence, and prosecutors said those findings will show that Mr. Huerman killed 7 women. It's that simple, according to the prosecution. We, of course, will give him the presumption of innocence. Anyway, DNA is at the core of the prosecution's case against the alleged killer, Mr. Huerman, but defense attorneys claim the science, nuclear DNA, has never been used before in New York court at all. And Huerman, who was there in court along with his attorney, Mr. Michael Brown, claimed that prosecutors were hanging their case on forensics found on the strand of hair from each of the 7 victims. Now, the California lab that performed these tests, he argued, is not certified in New York, and therefore the whole case must be thrown out. Anyway, the district attorney defended the use of the evidence and noted that the science has been around for many years. And they said this is the first time we're taking a sound science and applying it to the criminal coverage area. It is the field of DNA analysis accepted both in New York State and the country, the prosecutors noted. Anyway, the judge granted the defense another 2 weeks to receive some more DNA evidence that is caught up in apparently some sort of lengthy download situation. Anyway, the defense says they call it science. We're disputing that, and we're looking forward to getting things that we're entitled to. We're still waiting for a significant portion of discovery that they're entitled to, and then they'll be ready to proceed forward, the defense noted to the court. Mr. Huerman has pled not guilty to first and second degree murder in the killings along the Gilgo Beach of Melissa Bartholomew, Amber Lynn Costello, Megan Waterman, Maureen Brainerd Barnes, Jessica Taylor, Valerie Mack, and Sandra Costilla. In another argument in court, the defense called for separate trials, contending that the one trial influences the jury when so many allegations are lumped together. The defense is saying, hey, these cases have nothing to do with each other in the sense of other than the sense of location where the bodies were found, type of murder that was committed, and the evidence that they have. They have no business trying some of these in court being tried at the same time, the defense is arguing. Now, the prosecution said that it's a serial killer case and that they all belong together at one trial. The prosecution said, hey, this guy's a serial killer who methodically hunted and murdered 7 women. That is our case. A lot of the evidence of one charge should be admissible in court as evidence of the same charge. Now, after a year and a half, the judge in this case appears to be running out of patience and is somewhat eager to move the cases to trial. He has now ordered everyone back in court on March 12th for further consideration as to whether the DNA evidence from California should be admissible at trial. These cases need to be moved along. Obviously, I'm not a big fan of 404B evidence, but this is the kind of case where 404B evidence probably comes in. It shows a pattern that takes place. And if you can link all of them together, even if they're not all tried together, then you bring them in as 404B evidence to show, hey, judge, this is our guy. This is the similar conduct that took place in each and every one, i.e. sex workers killed, buried along the beach. Oh, and by the way, we just happen to have some DNA evidence from Mr. Huerman on all of them. Kind of shows kind of an absence of mistake, modus operandi. I think that will come in. And I get the judge's frustration. I get it. 7 homicide cases. It's not going to drag on forever, but you got to give everybody a fair chance to take a look at it, challenge the DNA evidence, and move on. Let's face it, DNA evidence is not new. It is generally and widely accepted. You don't need to have a Daubert hearing to go into that anymore. And certainly, if there are challenges to this DNA evidence, it can be brought up on cross-examination. It doesn't mean that all the DNA evidence is not coming in. Next, a Texas teacher was arrested again. That's right. A Texas high school teacher has been locked up again on a new charge after she allegedly had sexual intercourse with one of her young students. Please meet Molly Spears. She was arrested again on Thursday morning and has now been charged with 2 counts of after previously charged with having an improper relationship with a student. Now, Miss Spears of Baytown, Texas, is being accused of engaging in sexual intercourse with a male pupil at the Barbers High School on June 12th of 2023. Now, she was arrested for the second time for the new charge on February 27th on 2 counts of assault on a child and is being transferred to the county jail. Now, earlier this month, Ms. Spears was indicted by the Chambers County grand jury for the improper relationship charge, and she was arrested on February 11th, 2025, after she self-surrendered to the court. She posted a $50,000 bond, and guess what? Now she's being held on a $200,000 bond. Now, on her initial charge, Spears was accused of having engaged in the sexual contact and sexual intercourse with the boy. Spears was previously listed as a high school language and arts teacher there at the Barber High School, which is near Houston, Texas. Now, the school obviously issued a statement in saying that, guess what, Miss Spears resigned back in June of 2023. I just don't get it. Miss Spears seems like a lovely young woman, thinks she'd be able to find somebody her own age to mess around with, and maybe somebody that wasn't worth going to prison for a lengthy period of time and having to register as a sex offender. Now, obviously, we will give her the presumption of innocence, but if the allegations are true, assuming arguendo for the sake that they are, poor decision-making. And next on the docket, this day in legal history, on February 28th, 1911, President William Howard Taft nominated William H. Lewis as the first African-American Assistant Attorney General of the United States. Obviously, Lewis' appointment, given the time frame when that took place, was quite a groundbreaking step toward racial integration in federal legal positions. And on this date in 1966, Miranda v. Arizona was argued. That's right. The United States Supreme Court heard argument in the case of Miranda v. Arizona. It's obviously the landmark case that led to the establishment of the Miranda rights. You know it. You've seen it on TV. You have a right to remain silent. Anything you say will be used against you. If you can't afford an attorney, we'll get you one, right? Completely made up law. Nowhere in the Constitution does it say you should be advised of these Miranda rights. But the United States Supreme Court said, hey, things aren't always fair when you're dealing with the cops and the prosecution and the government. So we're going to warn you that before you talk to the police, anything you say can and will be used against you. And what I've generally found is most people completely ignore that advisement. The United States Supreme Court says, hint, hint, wink, wink, nudge, nudge, don't talk to the police. But we're even going to go one step farther. Instead of just putting it in a case, we're going to make police officers advise you if you're in custody and you're being interrogated on the matter that they're investigating. And people still ignore it. They all just want to find out what was going on and usually talk themselves into a conviction because most of the time it's the defendant's own words that get them convicted, ladies and gentlemen. So remember, lawyer, lawyer, lawyer.
All right, lawyer, lawyer, lawyer.
That's what you say when you're being interrogated. And on this day in 1993, the Waco siege begins. That's right, a gun battle erupted at a religious compound near Waco, Texas, when the Bureau of Alcohol, Tobacco, and Firearm agents attempted to arrest Branch Davidian leader David Koresh on firearms charges. The ensuing 51-day standoff raised serious questions about federal law enforcement's tactics and led to the extensive legal and congressional investigation of the entire incident. You know, that's the one where they went in to arrest him and they started shooting back. Siege ultimately resulted in a big fire and several people dying. Next, our dumb criminal of the day. Now, this is truly dumb. A New Hampshire woman was arrested after police found footage of her urinating on food products at a local grocery store. And what did they find on her phone? That's right. Similar acts going back for several years, 4 years to be in fact. Please meet Kelly Tedford. Don't let her hang around your kitchen alone. Yeah, that's right. She allegedly tainted a slew of products at the Monodoc Food Co-op in New Hampshire with her urine, costing the grocery store roughly $1,500 from the ruined products as well as cleaning expenses. The grocery store also had to issue a recall for its organic quinoa, cornmeal, polenta, coconut shreds, and raw walnuts after Tedford had apparently relieved herself on all of those products. Now, it wasn't Tedford's first time peeing in those places. No. It was apparently a hobby for her. Police recovered multiple videos of Miss Tedford that she posted online showing her peeing on produce services and other objects. The oldest video goes back to 2021. Now, Miss Tedford was released on her own personal recognizance bond. She has to go back to court on April 7th. Police have launched an investigation with additional criminal charges possible in the future. Right now, she's only been charged with one felony criminal mischief count. Well, Miss Tedford, our dumb criminal of the day, we'll give you the presumption of innocence. I'm sure that's not you peeing food items in grocery stores over the last 4 years. It's probably somebody else. You were just the videographer of it all, I'm sure. Either way, if you did this, Miss Tedford, first of all, you're dumb. And second of all, you're just gross. That's just gross. Anyway, that's all we have for today. Have a wonderful weekend. We'll see you next time on Crime Talk. And remember, the Constitution matters.